Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA.
Kreller has been the leader in enhanced due diligence involving FCPA compliance programs since 1988. Our boots-on-the-ground research combined with our in-house team of licensed investigators allows us to continually outperform even the most sophisticated database providers. For the past 30 years, Kreller has become synonymous with high-quality, decisionable reports that uncover hidden truths that our competitors routinely miss. Kreller also has a best-in-class case management system, Kreller Online, which allows for companies to develop and administer their own questionnaires, risk ranking scoring, and third-party training, while continuously monitoring the companies and shareholders through worldwide sanction lists.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Nashville on May 3rd through the 4th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash, sponsored by Kreller. This is Professor Mike Kaler, and in today's episode, I am very pleased to be joined by Camilla de Silva. She is the Joint Head of Bribery and Corruption at the United Kingdom Serious Fraud Office. Thanks for joining me today.
Sure, no problem, Mike.
Hard to believe, but the Bribery Act went live in 2010 and is not too far away from its 10th anniversary. And when analyzing whether the Bribery Act has been successful in achieving its objectives, what do you think is the best definition of success?
Okay, well, the Bribery Act came into force in July 2011, and it's not retrospective, so it's not really accurate to describe it as going live in 2010, and it's not quite reaching its 10th anniversary yet. Looking at the definition of success, it's not really within my remit. Parliament passes legislation and then reviews its implementation and application. The Ministry of Justice has announced a post-implementation review of the Bribery Act to take place within the next 2 years to test its effectiveness and impact on tackling corruption. And that's a standard procedure for major UK legislation. However, there are independent sources of commentary on the successful application of the Bribery Act, for example, the OECD. Indeed, the chairman of its anti-bribery working group, Drago Kos, when he launched the OECD's recent evaluation of how the United Kingdom had met its obligations under the OECD's Convention against the bribery of foreign public officials, he described the Serious Fraud Office as one of the best law enforcement agencies in the world at fighting foreign bribery. And of course, I would say that assessment is based in part on our successful use of the Bribery Act. So I would suggest that is an indicator of its success. As your audience will no doubt know, Mike, 5 years ago, our director, David Green, refreshed the mandate of the Serious Fraud Office so that we take on the lead on investigations into bribery, and where that involves a degree of complexity or seriousness that requires the use of the Roskill model to investigate and, where appropriate, prosecute. And the SFO is the United Kingdom's lead agency in relation to the investigation and prosecution of overseas bribery. There are some cases that don't trigger our take-on criteria and are properly handled by other UK law enforcement agencies. But just talking a bit about that, we have numerous bribery and corruption cases on our books, some involving potential offences under the Bribery Act 2010, and others where relevant conduct predates the Bribery Act or it comes across both pre and post. And these cases are complex, involving huge quantities of material, often evidence suspects located in numerous different jurisdictions. So investigating a major corporate entity for foreign bribery is a lengthy process, and it takes time before we can reach a point where, as a prosecutor, we can decide whether there is sufficient evidence to bring charges. But we have used the Bribery Act to bring charges. For example, the Serious Fraud Office brought charges against the Sweet Group in 2016. There was a guilty plea in relation to that. Sustainable Agro Energy, 2014. There were 2 convictions in that, 1 acquittal. And more recently, we've charged individuals and the company, FH Birchling Limited. They were charged with making corrupt payments to an agent of the Angolan state oil company Sonangol, and we've brought Bribery Act charges in relation to conduct by the agent Unioil. And we've also resolved a number of deferred prosecution agreements on the basis of Bribery Act offences, such as the Standard Bank, DPA, and the Rolls-Royce resolution. I think finally, in relation to indications of its success, it's perhaps a sign of its success that the failure to prevent model, which we first have seen in the Bribery Act, is being used as a model to extend corporate liability into other offences. So we've recently seen in the Criminal Finances Act 2017 the extension of corporate liability to cover an offence which is the failure to prevent overseas tax evasion, and that came into force on the 30th of September of last year. And that offence targets corporate bodies, making them criminally liable for the acts of their associates if they facilitate someone to evade tax overseas. And there is, as under the Bribery Act, a potential defence if the corporate body has reasonable prevention procedures in place. And we, the SFO, will be one of the agencies investigating and prosecuting the overseas offence, partly due to our expertise in combating international crime. And we've also seen the government is considering the extension of the failure to prevent model to prevent economic crime more generally. And the stage that that's reached is where the government is currently looking at the results of the call for evidence, which came out of its consultation announced at the Anti-Corruption Summit back in May 2016. And only a couple of days ago, the Minister, the Solicitor General, Robert Buckland, is reported to have said that there was a strong case for a new corporate offence of failing to prevent economic crime, and that it was time to set it in statute. And that's a position that the SFO have been advocating for some time, that if the public want to see more successful prosecutions of corporates, then that change is necessary. So I think that's a fairly good indicator in the round of the success of the Bribery Act.
Yeah, many laws, whether it's the Bribery Act or the U.S. Foreign Corrupt Practices Act or many others, have both a hard enforcement impact, i.e. actual prosecutions brought and settlements reached, and that's largely what you've been referring to. But laws also have what I'll call a soft enforcement impact. In other words, corporates are conforming their conduct to the law because of specific elements or provisions in the law, and because of that never come to the attention of the Serious Fraud Office. I'm wondering about the soft enforcement impact of the Bribery Act, and in particular, what your viewpoint is regarding the adequate procedures defense, something obviously the FCPA does not have as a matter of statute, and whether you've seen corporates conforming their conduct to the law because this adequate procedures defense perhaps provides an extra motivation to do so, and thus is a soft enforcement impact.
Yeah, I mean, I think it's difficult to quantify and judge whether success is due to, as you describe it, the hard or soft enforcement. And in some ways, I'm not sure it much matters if what changes is the corporate culture and good governance. As I see it, we have specialist compliance officers who are trying to impart their knowledge to their clients and their business that they know and which employs them, so that those businesses can be confident that they're doing clean business in the environment their organisation is operating in. Ours is obviously a different role. We're here to hold business and individuals to account when those compliance procedures, if they exist at all, fail. And ultimately it will be for the courts to make that determination whether an economic crime has been committed and whether a company's compliance program is adequate enough to form a defence under the Bribery Act. And since the passing of that, we, the SFO, have yet to encounter a corporate with sufficient confidence in its compliance program to persuade us of its adequacy or run a Section 7 defence argument in court. The Crown Prosecution Service have recently had a case, and that Section 7 defence argument failed, and the jury did not accept it. So I think the starting point is about having bespoke compliance procedures in place, but it's more about the substance of those procedures and them actually working in the first place. And it's about proportionate procedures, the interaction between and impact of the compliance team on the business unit, top-level commitment from the board, the proper governance, and organisation of compliance, and that this asset is properly resourced, and crucially that there is a bedding in of that compliance culture. But yes, I think from where we sit, it is clear that the Bribery Act has led to a significant amount of work by companies in developing stronger and more ethical corporate cultures. I think that, again, that could be seen as a success.
The body of best practices for compliance has, been in the public domain for a long time. With release of the Bribery Act, the Ministry of Justice put out guidance and what adequate procedures means. In this space, in the last year and a half or so, best practice potential metric that's gotten a lot of play, at least in some circles, is so-called ISO 37001. What is the SFO's position on this ISO standard and how that may relate to whether a corporate has adequate procedures?
Well, it is well known that our Director of the Serious Fraud Office, David Green, has stated that we do not give guidance on what a good compliance program looks like or provide official guidance on adequate or reasonable procedures. We are a prosecution agency and not a regulator, and so that's not our job. And of course, what is applicable to one business is dependent on that business, and it's pretty artificial for us as prosecutors to lecture on what is adequate or reasonable for a particular organisation. So I think it's fair to say we don't have a position on that. That is for others to determine and judge. And although we don't have official guidance from the Serious Fraud Office on a major case dealing with adequate procedures, as you say, Mike, there's not a vacuum of information available, quite the opposite. There's a lot of guidance from both the Secretary of State's published guidance pursuant to Section 9 of the Bribery Act, as you've talked about, as well as the OECD's helpful case studies. And furthermore, the compliance-related comments contained in the Rolls-Royce and Standard Bank DPA documents, while obviously being fact-specific, could also be a useful source of information from that compliance perspective as to where issues arose, suggestions for enhancements, and what is needed for remediation. So that's the long answer. So the short answer is we don't have a position on the ISO 37001.
You mentioned earlier the Rolls-Royce prosecution, and I'd like to ask you a couple of questions regarding that. The United Kingdom, much like the United States, and this question is one I've posed in relation to certain FCPA enforcement actions as well, The United Kingdom is party to the OECD Convention, and Article 5 of the OECD Convention basically says in pertinent part that investigations and prosecutions should not be influenced by considerations of national economic interest, the potential effect upon relations with another state, or the identity of the legal persons involved. Now, reading the Rolls-Royce resolution documents, it at least sure seems to me that this prosecution was in fact impacted by the identity of the legal person involved. Indeed, in some of the resolution documents, it was noted that Rolls-Royce is a company of central importance to the United Kingdom. An actual criminal conviction against Rolls-Royce would have a substantial impact on the UK defense industry and many others. So my question is, against this backdrop, how can one not conclude that the resolution of Rolls-Royce was indeed influenced by considerations of national economic interest or the identity of the legal person involved?
Okay, well, I think we're going to disagree there, Mike, because in fact, if you go back to the judgment of the president of the Queen's Bench Division, Sir Brian Leveson, that passage that you read out from the judgment is followed by this sentence, which is, none of these factors is determinative of my decision in relation to this DPA. Indeed, the national economic interest is irrelevant. Neither is my decision founded on the proposition that a company in the position of Rolls-Royce is immune from prosecution. It is not. It is not because of who or what Rolls-Royce is that is relevant, but rather the countervailing factors that I have to weigh in the balance when considering the public interest and the interest of justice. And I think that's one of the joys, the absolute joys of our system, is that we have an independent scrutiny of our work. So our analysis is scrutinised by, in this case, a very senior judge of the United Kingdom, England, Wales, and that detailed analysis is available to the public. So you can see what the decision-making was and the analysis. And I think it's right to say that the DPA tool is one that has been adapted from the US model to suit the British context, and that does mean, as I say, judicial oversight. And the invitation to negotiate a deferred prosecution agreement with a corporate is a matter for the prosecutor's discretion. But crucially, as I say, there is then the judicial oversight before any proposed deferred prosecution is approved. And then at the end of that process, the statement of facts, the terms of the DPA are published, so can be seen. And I think when you see what the judge is saying, you can see the proper context of it. Under DPA, of course, the prosecutor charges a company with a criminal offence, but if the judge agrees, those proceedings are suspended and conditions imposed. So those terms might include, as they did here, a fine, disgorgement of profits, payment of cost, changes to governance, and remediation in relation to compliance issues, and potentially the appointment of a monitor and compensation to victims if that's appropriate. So in no sense is a DPA the product of a backroom deal or constitutes some sort of a get-out-of-jail-free card for the corporate. And if the company doesn't honour those or meet its obligations, the prosecution will resume. Of course, when a company is convicted of a criminal offence, the court can impose a fine or put its business out of action by winding it up. And both of those outcomes can cause collateral damage to employees, shareholders, pensioners and others. The DPAs are designed to avoid that, where there is a cooperating company, and it also avoids the need for lengthy and expensive prosecutions. But our default position at FFO is to prosecute. It's only if the public interest factors outweigh it that default position will be moved, and we will look to invite a company in to negotiate a DPA. And as I say, it then has that judicial oversight and needs that before a DPA can be settled.
So we've both quoted from the judge in this case, and I guess it's up to listeners to decide which one of those portions from the judge's ruling is most relevant, and that's an open question, I guess. I will completely agree, just as a commentary point, that if a country is to have a deferred prosecution regime, that the UK regime is much more preferable to what we have in the United States. And I think it's notable for listeners to recognize that even the UK was not willing to entertain non-prosecution agreements, which are another prominent fixture of the FCPA landscape here in the United States. The final question I'd like to ask concerns, I know something that the UK has wrestled with other law enforcement agencies, and that's multi-jurisdictional issues in bribery offenses. Obviously, it's a small world, and transnational conduct can provide various law enforcement agencies with a potential nexus to bring in enforcement action. But then again, looking at it from the corporate side, how many enforcement actions is necessary? So my question is, which country, in your opinion, has the greatest interest in prosecuting bribery offenses? Is it a country like the United States, perhaps, that may have jurisdiction because the company's shares may trade on a U.S. exchange? Is it the home country, so to speak, where the alleged bribe-paying company is located? Or is it perhaps the law enforcement agency in the country or countries of the alleged foreign officials who were bribed? What's the UK's approach to wrestling through, navigating these very complex, in many cases, jurisdictional issues, which are not only legal in nature, but policy-driven as well, I guess?
So our starting point will be that we are interested in policing our own, be it a UK corporate or individual. And part of our take-on criteria is a consideration of whether the alleged conduct undermines UK commercial, financial, PLC in general, and in the City of London in particular. So it is important, in our view, to agree the split of our investigation at an early stage, if possible, in order to prevent duplication of work, avoid potential legal problems further down the line, such as disclosure and admissibility issues. So we would initially look to apply the Eurojust guidelines on overlapping cases and look to identify key factors such as where the conduct of the corporate or subsidiary companies took place, the location of the main suspects, the witnesses, and the evidence, and to what conduct laws on corporate criminal liability are best suited. So, for example, on Rolls-Royce, this approach allowed us to split the investigation, which encompassed numerous jurisdictions and suspects, in a fair and objective way. And there was significant strategic benefit to us to do this, and ultimately, as you know, it led to a tripartite global settlement orchestrated by the SFO, DOJ, and the Brazilian MPF, reaching a leniency agreement with Rolls-Royce. And more recently, we've addressed overlapping interest in respect of Rolls-Royce individuals whose conduct arose from the SFO and DOJ's investigation of Rolls-Royce Energy, that particular business strand. And in resolving our primacy, our focus has been, in part, which agency held the best evidence from its investigation, as well as which whether jurisdiction could be properly asserted. And as you and your listeners will well know, in this case it was the DOJ, which recently secured 4 guilty pleas back end of last year, and we supported the Department of Justice by providing significant assistance on our part to the investigation, and our investigation into individuals continues. But of course, we acknowledge it's not always possible to agree primacy early early on, and there are times when those issues are difficult. They're very nuanced, and parallel investigations will be ongoing, and that is going to be difficult for corporates where there is different demands being made by different law enforcement agencies. But we are alive to those issues, and where possible we try to resolve them and come to agreements between ourselves. So as I say, there are times when that is not going to be possible because of the differing systems that we work under. And just on your point, Mike, about it being a small world, I think one thing to note of interest is this, that it is a small world, and I think it's getting increasingly smaller. You will know that there are well-established trends of cooperation between authorities, both within the United Kingdom and, of course, abroad. And we closely work with our partners in Europe, in the Americas, Australasia, and beyond. And that's because, in part, the transborder nature of financial crime means that those links will only strengthen. But interestingly, they are strengthening not just in the area of operational cooperation, but also in the exchange of ideas, such as deferred prosecution regimes and how they are suitably adapted into other jurisdictions. And that work is something that we are deeply familiar with, sharing our practical experience and the lessons we have learned since the drafting of the DPA Code with those that have asked us to. Interestingly, those jurisdictions with whom we have shared ideas, who are looking to or have created DPA-esque regimes and passed legislation to enable that, they appear, interestingly, to be looking at emulating the UK model and the way that we approach DPA, such as the judicial oversight and potentially compensation to be paid to victims. So just picking up on your point about the different DPA models, I thought that might be of interest too.
No, and I completely agree with you, whether it's Canada wanting DPAs, Australia wanting DPAs, the French DPA regime. If a country is to have a DPA regime, and that's a policy question that can be had, if we answer that yes, I think the UK model is far more preferable than the US model, and have said and written that many times. Today's guest has been Camilla de Silva. She's the joint head of bribery and corruption at the United Kingdom Serious Fraud Office. And I thank you very much for providing your insight and perspective to FCPA Flash listeners.
That's my pleasure.